Good morning, everyone. So here it is 9:20 a.m. and you're already hearing from the lawyer. So you know what this conference is going to be like, right? When you start with the lawyer, particularly with a full room. I don't know the last time I've ever presented and had a room so full. I sort of want to take a picture and send it home to show people that people do actually show up to my presentations. So, how many of you were at Seattle last year? Good number of hands. Okay, so I had the chance to speak to many of you last year, but how many of you remember what the temperatures were in Seattle last year? It was cold, right? Matter of fact, we had snow in Seattle the same week that you all were in Seattle, which is not usual for Seattle. And so we were joking earlier today, Seattle, it's frigid. New Orleans, it's frigid. What is it about these conferences? You know, you saw San Diego listed earlier. Someone should call San Diego probably today and let them know they're going to have a really cold spell this time next year. So, well, welcome to all of you. Welcome to New Orleans. I'm happy to be here. Thank you for having me back. The plan for my short 20-minute presentation is to go through some highlights with you. It says legal views. It should say Greg's views. These are my views. These aren't the views of anyone else. And then after my 20-minute overview, Sean's going to join me on stage here, and we're going to try to field some questions from you all. We'll do some live questions. I think Sean has some questions prepared, but to give you a chance to ask questions of me and to Sean and I about anything that may be on your mind related to these topics, we're hopefully going to have enough time to field some of those questions. So let's get going. So what are we going to talk about in 20 minutes? I have 6 topics, 6 slides, and you may be wondering, why am I qualified to suggest only 6 topics? Here's how we came up with them. For the last 8 years, I have published an online travel summary, which is a weekly summary that we send to clients and we put on our blog every week. Every year, at the end of the year, we go through the top stories over the prior year and try to identify what we felt were trends that we were seeing. That led to these topics. You're also going to see, or the topics will reflect, a lot of the input from many of our clients. So we work both on the supplier side, primarily in hotel and cruise, and we also work with a number of platforms. And so they too helped come up with this list when we asked them sort of what did you see in 2023 and what do you expect to roll over for 2024? And then our friends at Hedna also had some input on our list today. So with that, let's get started. We're going to go quickly. Again, questions hopefully at the end if you have some, but we have a lot of material to cover in a few short minutes. Junk fees. So we already saw the video, right? Not our term necessarily, but President Biden's perspective. I prefer to refer to them as resort fees maybe, or mandatory fees. But why are they so important? So I won't get into too much legal detail with all of you, but a history lesson here is important. Go back to 2012 when our friends at the FTC, U.S. federal agency, sent letters to many hoteliers suggesting that their practices around mandatory fees were less than adequate. Right? There was no specific law about them, no specific rule or regulation, but it was felt that it was misleading in the way that the fees were being presented at or prior to the time of booking. So that was 2012. What followed from then over the next few years were a series of class action cases that were brought by consumer groups against a number of hoteliers, leveraging what the FTC had said and suggesting that they would be entitled to some form of monetary recovery for failing to disclose fees. Several states got involved. Our friends in Pennsylvania got involved and advanced to 2021 when Marriott and Pennsylvania, the AG from Pennsylvania, announced their settlement. I'm sure many of you are familiar with that settlement, but 2 concepts came out of that in 2021. One was the notion of total price. Hopefully by now everyone understands what total price means, but for those of you that don't, it simply means the rate and the mandatory fee. It does not mean tax necessarily, unless you're in, for example, in the EU where all-inclusive pricing may be required. But here in the US, it meant, or still today, only means rate and fee. Many people get confused and throw tax in there, but that's not what it means. The other thing that came out of the settlement was this notion of being the first price that's listed, or the first price that's identified, or the most prominently displayed price. That's what the AG settlement is focused on, is that most prominently displayed price and ensuring that that price is the total price. So that's 2021. Fast forward to 2023, and man, have things gone to hell, right? We have states now, we have particularly our friends in Texas, the attorney general there trying to distract from his own political challenges, decided to go after the industry and brought suit against many suppliers and at least one platform. Our friends in DC, Consumer Group, have brought claims against several of those same suppliers, all arguing that their disclosure practices are inadequate. Then the Federal Trade Commission gets involved and notifies everyone that it too, or it plans to introduce rules. And in fact, at the end of the year, we saw their rule proposed. Then comes California. Man, you gotta love California, right? Any topic, they wanna be first, they wanna be out of the gate, they wanna be the most comprehensive. And California has passed 2 bills, one of which is most important, which will take effect in July of this year, requiring total price. Now you may be thinking, okay, I'm not in California, the FTC rule isn't effective yet, why should I be worried? Well, the California rule is very, very broad. California rule applies to anyone with a location in California, or if you're selling to someone traveling to California. How many visitors each year go to California? The effect is quite broad. So, what do I expect for 2024? A, California's rule will become effective. Other states are lining up behind California to do something similar. Unfortunately, as many of you know in other contexts, when states start doing that, nothing is ever uniform. So many are advocating that we need a uniform standard, whether it be the FTC, whether it be federal legislation, which by the way, there are 2 bills, maybe 3 now, proposed in Congress to address the issue. But most everyone in the industry wants one standard that we can all live by. Until that happens, unfortunately, we're likely to have a patchwork of rules that speak to junk fees and resort fees. So there's junk fees, 2024. FinTech. How could you do a presentation without FinTech? The thing I've learned and realized is that FinTech means a lot of different things to different people, and the effects of that in 2024 will vary based on what your view of FinTech is. So for many people, it's a payment platform, facilitated payment platform, whatever it may be. It maybe perhaps is a payment method. Maybe it's a unique currency. Maybe it's an electronic currency. Maybe it's something, a unique way to pay over time, right? Our friends at Hopper built a company around some of their unique payment methods and payment tools, which allowed them to leverage those tools and to grow the platform that they have. For others, FinTech speaks to the financial company travel platforms that we're now seeing grow like crazy. So whether it be our friends at Chase or Capital One, where they are taking an enormous loyalty program, right? How many card holders do each of those companies have? And they're leveraging their card holder base and the points that they generate through the use of those cards to then use them as a new travel currency. So why is this up here? The reason I throw this out here is because for those of you on the supplier side, rate integrity, rate parity, all of those concepts I suspect will continue to evolve and be somewhat turned on their head with the introduction of all of these new currencies. What a rate is in dollars is very different than what a rate may be in a dollar plus loyalty program benefit or immediate cash credit or whatever it may mean. It may change the notion of rate parity in ways that you don't expect. The other point I want to make here about the financial companies entering the business is that they have the resources, they have the loyalty user base, and they have the creativity to become behemoths in this industry. They're growing quickly. They have a lot of aspirations as to how quickly they want to grow and what size they want to become. And I expect that over the next few years, we'll be talking about those platforms as much as we perhaps today talk about OTAs or GDS or what have you. I suspect conversations around those platforms will only grow this year and next. NDC. Many of you may be saying, this isn't an airline conference, why are we talking about NDC? Yes, it is primarily airlines, at least airlines have taken this burden, if you will, upon themselves to force the issue. But I use this slide simply to say that I suspect that this year and maybe next year, excuse me, will be my term, no one else's, the year of GDS. And what I mean by that is, from a GDS perspective, they are starting to see pressures unheard of in years past from both sides of the equation, right? Their corporate clients are saying that we want new content. We want to receive rooms and rates through new channels. We want to lower transaction costs. Suppliers on the other side are saying many of the same things. Our customers are demanding this. We wish to lower transaction costs. Our customers are asking to access through new channels. What are we to do? So you take those pressures, you take the debate which someone spoke of earlier about, well, do the hotels need to step up with technology, or do the technology providers need to step up with technology? It puts everyone in an interesting mix. And from the lawyer's perspective, add on to this the fact that many GDS contracts were written in the 70s. I always find it humorous when a client sends a contract, a GDS contract, and says, will you tell me what this means? And the date it was written, I was 4 years old. So take the evolving nature of GDS and that form of distribution, add an overlay of that of terms and conditions and policies and laws that literally date back to the 70s, and it makes for a very interesting mix that I expect people will spend a lot more time thinking about over the next year or two, particularly outside of the airline industry. Artificial intelligence. How could we not talk about artificial intelligence, right? Well, for those of you that haven't been following the legal side of AI, 2024 will be the year of regulation. I'm sure you've all read about the parade of horribles that inevitably will occur because of the introduction of AI in our lives in so many different ways. Well, you better believe that legislatures and regulators are now thinking about this. For those in the EU, you probably know that the Artificial Intelligence Act is now not fully passed quite yet, but expected to be soon. And many countries outside of the EU are looking to the EU and what it adopts as the model for what they will adopt. So if you've not looked about anything about what the EU has done, it essentially is taking upon itself, the EU Commission, to evaluate AI and its uses and characterize or classify it based on the perceived risk of the tools involved. So now, for example, a chatbot that you might have on your site to respond to travelers' requests, that's considered a low risk. Interestingly, generative, sort of interactive AI platforms like ChatGPT has already been characterized as a high-risk platform. So what does this all mean? Largely, it means greater transparency. The requirements will require those with those platforms to provide greater transparency to users and regulators as to how those platforms are used. And I suspect that we will see more regulation. I know the US is looking at what the EU has done. I know countries in Asia are looking at what the EU has done, and I suspect we will see more regulation in the year to come. Now, for those of you that are new to the AI conversation and don't quite appreciate what the risks might be yet, there's a couple of things I want to highlight for all of you, which I've been doing in every presentation we've been given for the last year, which falls into, one, hallucinations. Everyone familiar with that term means in the world of AI? Simply means that AI is wrong. There are some great examples out there where people have mistakenly thought that AI was the end-all be-all and fed it information hoping for a correct answer, and in fact, what it produced was completely wrong. One great example in the legal profession is that a lawyer, an enterprising lawyer in the East Coast, decided to have AI write its brief for it and decided that it would give the case materials to AI, give it the relevant facts, and have AI create the legal briefs. Interestingly, what AI produced was very well written, but every case citation, every statute, and every regulation didn't exist. Talk about creative lawyering. So first of all, keep in mind that AI is not always right. The second thing, which is so important, is or relates to our IP or intellectual property. So what does that mean? Copyrights, trademarks, some things that are very near and dear to you and your company's future, frankly. Many times, if you feed this information into an AI platform, at least if it's a public platform, it then becomes public. So if you're using a trademark or copyright or something that you wish to protect, but you start loading it into AI, you may lose the protections that you've fought so hard for to create that IP, but then what comes out of AI cannot be protected. It's already quite clear, at least under US law, that even if EI writes for you the most amazing marketing plan, none of that can be protected. Final point, confidentiality and privacy. What you put into these open AI platforms, these open systems, if it was confidential, you should always assume that it is no longer confidential. Worst horror story yet. Enterprising hotelier came up after a presentation actually with HSMAI last year. And they were so excited because they had taken their P&Ls for the past 3 years, they had loaded it into AI, and asked AI to prepare for it a marketing plan, a revenue management plan, and a distribution channel mix plan for the following year. Now, the first question I asked was, well, did you use an open AI platform? Well, yes, I did. I wanted to have as much material out there as possible. Well, keep in mind, the second they loaded all of that information into that system, it became no longer confidential, but could be accessed and used by anyone who wished to use that same platform. So be aware of how AI is used in your organization. You will continue to hear a lot about AI and how it's being used in the travel industry. It's just something to be well aware of. What are we doing on time? Got to keep moving. All right, state and local tax. Boy, who loves taxes, right? There's a reason I didn't become a tax lawyer. I'm sure there's many reasons why you all didn't become accountants. So unfortunately, state and local taxes have consumed much of the work that we're doing today, particularly in the distribution space, primarily because of our friends here in the US. We've all thought for years that international tax is complicated and we rely on the experts, right? For those of you in the supplier side, your international tax partners or international tax programs or whatever, you rely on those things and those people for that stuff. I can handle US tax. That's not the case anymore. And the problem is, again, history lesson, dating back to 2018 when our friends at the US Supreme Court decided that you no longer had to have a physical presence in a state in order to be taxed there. So this you can blame on our friends at Amazon. So for years, taxes, with the advent of Amazon, states have complained that they should be entitled to tax revenue in their states when online platforms are selling goods and services into their state. Prior to 2018, states couldn't do that. Prior to 2018, states were required that the individual to be taxed have a physical presence in the state. After 2018, that is no longer the case. So with this decision in 2018, within months, states were trying to put policies and regulations in place in order to tax this online commerce that was occurring in their states. So fast forward to today. Important point. Every state in our country today that has a sales tax regime also has a rule, a policy, or a regulation about online sales in that state. So how many states with sales tax now? I believe, there's 46, 47 maybe? So start there, 46 or 47. Then add on top of that the fact that counties and cities many times also have their own tax requirements. By latest count, there are 11,000 county and city tax requirements related to online sales occurring in their jurisdiction. So imagine you're a platform. Imagine that you're selling hotel rooms at a hotel and I use Dana Point, California because it's the horror story. But Dana Point, California, you're selling rooms in that hotel. You meet the requirements of being an online platform or marketplace, which is the language most of these things use, which essentially means over an annual or a one-year period, you sell items, goods or services of roughly 100,000. And now you're subject to California's rules, even though you've never been there. you're subject to LA County, I believe Dana Point is LA County, and plus you're responsible for what Dana Point requires. By last count, there were 8 or 9 different regulations that impose tax on an online platform selling a hotel room in Dana Point, California. Now multiply that by 11,000. So that gives you a sense of how complicated it has become. In my experience, neither the suppliers nor the platforms understand these rules well. And frankly, it's a challenge because not only are there so many, but the rules change constantly. So next time you run into your tax colleagues in the hallway and you see them looking stressed, this may be one of the reasons, and this will continue to evolve. All right, regulations, last slide. So you may be wondering, well, haven't we been talking about regulations? What more do we need to know? So regulations, unfortunately, will continue to affect all of us in ways that we'll never comprehend, at least today. We've talked a little bit about tax, we've talked about AI, we've talked about junk fees. But regulations, in large part, thanks to our friends in the EU, have really had effect, particularly on the distribution world. As I'm sure many of you over the last year have been either firsthand experience or have been told by counsel or what have you, the rules around so many areas of distribution have been changing and evolving. So whether we're talking about keyword protections, or whether we're talking about resale price maintenance, or whether we're talking about channel selection, rules that have been adopted in the EU have a global effect. Reason being is that many times what the EU does and what rules that they create, as we saw earlier, other countries around the world follow suit. So this past year in September, the Digital Markets Act, DMA, Digital Services Act, DSA, focus on technology and commerce. Now many countries outside of the EU, South Korea, Japan, Australia, are looking at these same rules and regulations as a way to govern the same platforms that are there. So this next year, we're going to see a lot of changes, I suspect. The DMA, there's some question about some platforms whether or not they will become subject to the DMA and its requirements. That is unknown at this point, but we expect to know more. Also, inevitably, I'm surprised we don't have a full slide on this, privacy, right? Privacy continues to play an important role in all of your lives, and those rules will continue to evolve. GDPR, an acronym which we've not talked about, presumably everyone knows about GDPR. You should expect to see more requirements similar to what GDPR requires. You should expect to see those in other countries. So, with that, Sean, do you wish to come up and join me, and we'll do some Q&A. Thank you.
Good morning. Well, Greg, thank you very much.
Absolutely.
That's a lot of heavy content first thing in the morning.
First thing in the morning.
So appreciate that. So what we want to do is open everything up for questions, but I figured I'd toss an easy one to you.
Okay.
You talked about go back to the junk fees, and
okay.
Is there, with laws coming out of DC, out of Texas, out of California, with the FTC, are there clear guidelines what exactly constitutes these fee disclosures? I know you had mentioned a bit of it, but like even like a tourism tax, for example, is that a tax or is that a fee? I think there's people in this room that are pretty confused around some of that stuff.
As am I, frankly. So I didn't touch on, when we talked about regulation and taxes, one of the complicating factors under the junk fee rules that are being written. Some of them exclude, again, going back to this notion of total price. And as I said, total price must be a combination of rate and mandatory fee, but not tax. So to your point, is a tourism assessment a tax? Under some of the rules that have been written, so for example, Texas had draft legislation on this issue, and the Texas statute, which we helped with the Texas Lodging Association to help craft, we were very, very specific that tourism assessments were not a tax and should not be treated as a tax. If you look at California's rule, how a tourism assessment might be applied is not at all clear. it's going to require either clarification from the state at some point, clarifying the statute, or we're unfortunately going to have to wait until someone brings suit at some point and a court weighs in as to whether it's a tax or not. So unfortunately, there's no uniform rule yet, and until we have one and have an interpretation, it'll be an area of uncertainty.
Well, that sounds like it might be an opportunity for HEDNA to step in and try to help set some of those guidelines or get some common agreement anyway, right?
Yes, I agree.
All right. Anyone have any questions for Greg?
It's too early in the morning.
No, well, actually, I would really love if you can go. Thank you. I would really love if you can go a bit deeper on the California taxation for the fact that you're selling stuff to someone in California for the California data point, if I get it well.
Yes.
So are you somehow implying that whatever I sell from wherever I am, if I do it online to a California guy, I need to pay taxes in California? Or
Yes.
okay.
Yes. So go back to prior to 2018, unless you were physically present in the state of California couldn't tax you. And I'm talking about sales tax for now. They couldn't impose a sales tax on that transaction unless you had a physical presence. In the legal world, it's called a nexus, your relationship with the jurisdiction. That was prior to 2018. Along comes Amazon.com, online sales explode, and states recognize the millions of dollars of lost revenue that they're seeing because they can't tax transactions occurring primarily online in state. After 2018, states now have the ability to say to someone, if you're an online marketplace, typically $100,000 in sales over a 12-month period, and if you're selling goods and services into citizens, residents in my state, I can now tax you on those, even though you don't have a physical presence here.
Thank you. I got a follow-up question to that. So these online marketplaces, they're selling the grocery.
Grocery, okay.
All right, and then the
Grocery,
customer
okay.
travels, isn't the hotel remit taxes?
So it depends. So now we're getting really complicated. So for those of you whose eyes are about to glaze over, my apologies in advance. So it depends on the statute or regulation. Last time I counted, there were at least 33 different regulations that affected online hotel transactions. Some require the hotelier to remit those taxes, which is what the historical perspective has been. Others require that the platform collect and remit those taxes on behalf of the hotel. Part of the rationale here is to avoid this gross rate, net rate issue, right, which I suspect you were going to next, in that if I require the platform to remit those taxes, I can require the platform to remit those taxes calculated on the gross rate to avoid the loss associated with the net rate.
Right, so if everything went to a gross rate, it could just be submitted the historical way, right? And there wouldn't, right?
There could be if there was agreement on which of the two rates to be taxed, yes.
Right.
Which, as you know, there's no agreement on.
So the taxing authorities, are they indifferent whether, as long as they collect all the revenue on the gross rate? Are they indifferent?
As to who pays it?
Yeah.
In practice, yes. Some of the regulations actually specify as to between the two parties who needs to pay.
Right. Yeah. Unfortunately, that's right. If they understood the business, they may be getting the revenue anyway.
Yes. Right? Maybe another HEDNA opportunity there to educate some tax collectors. Good luck with that one.
Yeah, I was going to say that's a little bit more than you.
Yeah. Other questions? Okay.
A question that came up. Yesterday we were in our board meeting and we were talking about taxes and fees. And it was interesting perspective that was mentioned around like a non-accredited OTA adding fees. So like a booking charge or even a gratuity or a service charge that doesn't actually make it to the hotel. So they're just adding revenue or collecting extra fees. Is that also going to be regulated or policed through these fee disclosure?
Well, from a fee disclosure perspective, yes. If every online platform now charged a $25 per night booking fee, which I know some platforms do, but most of the majors do not. Yes, eventually, if it were felt that it too was a drip price or something of that nature, which, hey, they're only springing this upon me at the moment I check out, would you see pushback and regulation around that? Maybe one day you could. I don't think it's nearly prevalent enough yet to get regulators' attention in the same way that these mandatory resort fees have. But if you saw it being used the same way and enough people complained, possibly.
Yeah, it felt like a much different issue where it was the paying for services that actually weren't services at all. Like you paying a gratuity to something that it will never make it to the hotel.
Yeah.
Okay. Some of the AI stuff. I know that there's a lot of talk around how to optimize product offerings or pricing based on customer behavior or preferences, and they're using AI tools to do that. Is that what you're talking about when you say there's going to be a lot more regulation around how it's being presented or how?
Yes.
Okay.
Yes. And what I mean by that is if you're using a tool that is going to collect information about me, your customer, from various sources, and you're going to feed all that information into AI and hope that AI delivers to you the best possible product and best timing for that offer, what the offer may be, et cetera, to create those kinds of offers. At a baseline, what you should expect is that regulation is going to require transparency. In other words, you're going to tell me, the consumer, in some way that you're using AI for that purpose. Arguably, GDPR, again, back to privacy, GDPR already has some requirements about when AI is being used in certain disclosures. I think you're going to find requirements like that. One day will be uniform, that if you're using AI for those purposes, you've got to tell people about it. That's sort of the baseline. There will be more regulation on top of that if we're talking about highly regulated industries or infrastructure or what have you, higher risk sort of categories. You should expect to see more. But at a minimum, I suspect you'll see disclosure requirements letting people know that you're using those tools.
With the fee disclosure, I know all the hoteliers are well on their way of updating their points of sale,
Yep.
As well as our other OTA partners and whatnot. But it seems like the meta channels are a bit behind. Any insight as to what's going on there?
Yeah, so this is not at all an opportunity to bash people in the industry, but it's interesting because of our platform clients that have reached out to us about this. Whenever we go to them and say, well, it's quite clear what you need to be doing, let me send you a copy of this Pennsylvania settlement, or let me send you a copy of the California regulation, their first response uniformly has been, yeah, but why should I have to do this when I look at meta and price comparison and they're not? And the truth is that until California's rule becomes effective in July, which, by the way, is written broadly enough that it applies to suppliers and platforms, until you see that rule take effect and you see it being enforced, private cause of action, someone can bring a suit against, pick your favorite meta search site, on behalf of all of the consumers that have ever used that site. Until you start seeing that happening, I think inevitably there will be some participants that are slow to make these changes. And I'm not saying it's unique to Meta or platforms or even hoteliers. I suspect there's a number of small hotel groups that haven't gone through the changes in technology needed to make some of these disclosures, and they're just holding out as long as they can. And again, until these rules become effective and you start seeing broader enforcement, it may take a while before the changes occur.
Okay. Any other questions?
Oh, you have a hand. Hello.
Nice to see you again.
Good to see you.
So I have a couple of questions, and I'll kind of start with the taxes and fees. And certainly, I'm finding myself to become an expert in those things in a way I never
Yes,
dreamed I
reluctantly.
would have. Any recommendations, suggestions you have to suppliers on how to keep up with such a dynamic landscape? Like, I'll barely get some new tax legislation in place about remittance, and 4 months later, it's flipping back. So it's just the Wild West out there right now.
Yes. So a year ago, most of our clients were relying on letters from OTAs advising them of these changes. Some OTAs were all over this, and their letters were actually quite helpful. Today, most of the major accounting firms I know have practice areas, state and local tax practice areas that have focused on this. There's actually a group, many of you may have heard of them, called Alvera, I believe is the name. They're actually in Seattle, plug for Seattle. But they actually have, their tech platform is focused on state and local tax compliance for online platforms. So they have a really good grasp. As a matter of fact, a shout out to our friends at FocusWire and Focusrite. They just partnered to produce a white paper on state and local tax, which actually I read on the plane coming out here. It was so informative and so helpful. Unfortunately, for a supplier to tackle this successfully, I think it's going to be very difficult to do. Reliance on a third party, whether the PwCs of the world or an Alvera, I think is the name of the company name, I think it's going to require something like that.
Well, thank you. I appreciate that.
Of course.
Just one other question, because you were speaking about some legislation going into effect in California in July. There's another piece of legislation that we've gotten word about that has to do with refunding money if someone cancels within 24 hours, even if that rate is one that's designated as non-refundable.
Yes.
I'm not 100% familiar with it, obviously. We're just starting to look at that within
Yep.
Omni. Is it your perception that that applies just to customers coming into our California hotels, or does that apply to California guests staying outside of California, like coming into my hotels in Dallas?
So actually, I just read that regulation again this morning. I'm not sure it's clear. It's definitely the case if you're a California hotel that you must comply. My suspicion is that it also is intended to benefit California residents that are traveling outside the state. So in the same way that the fee disclosure requires broad application, my suspicion is that it applies as equally broad and affects any Californian who's traveling, whether it may be. And for those of you that don't know, I know you and I talked a little bit about this, the rule essentially says, which by the way took effect on January 1, I was surprised it took effect so quickly, if a booking is made with 72 hours or more in advance, that booking is cancelable and fully refundable if the cancellation occurs within 24 hours. I don't care, as she said, I don't care what rate it is, whether it's fully paid, non-cancelable, non-refundable. By California state law, you have a 24-hour period that you can cancel and receive a full refund. And the question obviously is, how broadly does it apply? I assume, given California's history, we should assume that it applies very broadly.
That's concerning, because I think we've interpreted it as just California hotels.
Okay.
For most of us that have talked about it. So if you're saying it's not clear and it could be more extensive than that,
Well,
that's going to change the industry considerably.
You should expect that there will be some enterprising lawyers in California that might one day take that perspective. But obviously, from the language of the regulation, it suggests that it's a California hotel issue. I don't think it would take a lot to say, well, what about the Californian who's traveling somewhere else?
Yeah, well, it's writing's on the wall, right? It's going to be just a matter of time before it goes outside of California anyway. Okay, interesting times.
Yes, definitely.
Any other questions before we let Greg go? It's a good opportunity to pick his brain.
No questions. Good.
All right, well, appreciate your time. Thank you so much.
Thank you.